and welcome to Discharge Upgrades, Military Records Corrections, and how to get connected to the VA with a less than honorable discharge. Brought to you by CalTAP and presented by Swords to Plowshares. So we'll start with the basics. Your discharge may affect your ability to access veterans' benefits, including VA health care, education benefits, and disability compensation. Many veterans receive less than fully honorable discharges. You are not alone. If you have a less than fully honorable discharge, you've probably heard a lot of misinformation on accessing VA health care and benefits. Things like you aren't eligible for VA benefits, you have to get a discharge upgrade from the military, or your discharge will automatically change to honorable after 6 months. Well, none of that is true. First, let's look at the discharge requirements and the kinds of discharges you need for different benefits. This chart may look intimidating, but if you look at the OTH, other than honorable, and BCD, bad conduct discharge columns, you'll see it says TBD. That's to be determined. So it means all is not lost. There's a process to get those benefits. The only exception really is that you have to have a fully honorable in order to get GI Bill or VOC rehab. So here are some specific instances that may have led to a less than honorable discharge. So one is, what if I was discharged under Don't Ask, Don't Tell, which doesn't exist anymore. You may be eligible to upgrade your discharge to honorable and or change your narrative reason for separation. Go to the Don't Ask, Don't Tell documents for more detailed information under these circumstances. What if my discharge is because of my service-connected injury or illness? Unless there is a statutory bar to benefits, you are still eligible for VA health care for service-incurred or service-aggravated disabilities. So what does that legalistic word salad mean? It means that there are certain statutory bars. Those are pretty rare. It's really if you have a court-martial, if you are an officer who resigned for the good of the service, a deserter, things that are really, really serious and pretty rare. Now let's talk about accessing mental health care, whether or not you've gone through the process of changing your discharge or getting an upgrade. For one, if you have an other than honorable discharge, you may be eligible for emergency mental health treatment for a period of at least 90 days. So if you're having a crisis, go to the VA Mental Health Care Center. Additionally, survivors of military sexual trauma are eligible for treatment for conditions related to that military sexual trauma, regardless of discharge status or other eligibility requirements. So if there's PTSD that's connected with MST or physical injuries that are connected with military sexual trauma, you are eligible for treatment. And vet centers, which are based in the community, they provide services for veterans with all discharge statuses so long as they've experienced military sexual trauma, served in a combat theater or other area of hostility, or operated a drone. Now, if you go to the vet center, you can get counseling, you can get hooked up into community services. They cannot give you medical care, so prescriptions and the like, but you can get counseling. So now we're going to get into the meat of changing your discharge or your character of discharge. There are two distinct routes: a VA character of discharge determination and a discharge upgrade and records corrections. These are completely different processes. Let's start with the VA character discharge determination. The VA looks at your character of discharge and determines if it should be honorable for VA purposes. And this can make you eligible for VA benefits except the GI Bill. So, another legalistic word salad: honorable for VA purposes. The VA will not give services to veterans who have served dishonorably. But they have a different definition or a different analysis beyond just looking at a bad conduct discharge or an other than honorable for deciding that you are honorable for VA purposes. Now, it doesn't change your DD-214, and it doesn't change the discharge itself. That will still remain in place, but you can get access to VA care and benefits. Now, it's important to remember that even though these are two different procedures, you can do them at the same time, and it may be in your interest to do so. You probably want to start with the discharge upgrade because that is very practical. That will get you into the VA for those healthcare services and those benefits that you need. So how long does it take? It takes a while. This is like other claims with the VA. It is a faster process than a discharge upgrade that we'll talk about a little later in this, but it still could take months to a year. But it's more likely to have favorable results than a discharge upgrade, which is why I said you should probably start with this process. So remember, don't do it alone. Before I was talking about statutory bars and different analysis and procedures. It's all very, very complicated and legalistic. So see the documents for more information and links to get legal representation and assistance for these services. So step 1, the process is triggered. You have an OTH or BCD, you go and you apply for health care at the VA, and they say, you're not eligible. Now, at that point, they are supposed to not make that decision at the healthcare entity. They're supposed to send that and start a process for the VBA to decide in your particular circumstances if you are honorable for VA purposes. But this is not always the case. Often they just say, oh, you have a BCD, you have an OTH, you're not eligible. So then that's when you go and you get help from a CVSO or a VSO or an attorney to get help with this process. So the first step is to gather your evidence. You're going to create a statement that details the circumstances around the events and conduct that led to your discharge. Now, this evidence is going to include medical records, but it also is going to include support statements from friends and family, fellow service members, letters from clinicians or doctors, anything that's relevant to help tell your story to the VA adjudicator deciding your case. Next, the VA sends a letter after you apply for the VA benefit to trigger the process. The VA will request relevant service records from the appropriate service department. At the same time, VA sends a letter to you that invites you to furnish any statements or evidence. Now, when I say they send it to you, you should have representation, so they should send it to you and your service officer or your attorney, and you can work together to put together the best package of evidence possible. So next, you can request a hearing. Now, you don't have to request a hearing, but it's a good way for you to tell your story, to present evidence and speak face-to-face with the VA adjudicator. It's much better than the adjudicator looking at a bunch of documents that are very dry and trying to really understand what your personal story is and how your service is honorable for VA purposes and that you should get health care and benefits. Now, you're submitting evidence as the claimant. You typically submit evidence on e-benefits or via fax or hand deliver it to a regional office. Again, you do this in conjunction with your service officer or your representative. So then what? You sit back and you wait, and the VA reviews all of the evidence and determines whether the discharge was, quote, under conditions other than dishonorable, unquote. And that is an administrative decision. So what do they take into account? It's the facts and circumstances surrounding the incident or incidents leading to your discharge and any evidence that you submit. So they're really considering the entire story, any mitigating or extenuating circumstances you present, supporting evidence provided by third parties who are familiar with the circumstances, the time that you spent in service, your performance and accomplishments during that time of service, and the nature of the infractions and character of service preceding the incident or incidents resulting in the discharge. So again, this is the story, and we talk about the supporting evidence provided by third parties. Those could be people in your unit who saw that suddenly something changed in your behavior, and that tended to show that perhaps you experienced a trauma, and that trauma led to the behavior that led to the discharge. So that's not medical records, it's not that kind of documented proof, but they're going to look at that, and you want to make sure they have it. So, now we're going to talk about discharge upgrades. These will allow access to VA benefits and health care and pave the way for other state, federal benefits, employment, etc., because it does change your DD 214. Okay, now that we're turning to discharge upgrades, I want to point out some important features. Most discharge upgrade applications are not approved. You want to maximize your chances and find a representative to help you with your application. It's also going to take more time. It can take several months. It could take up to 2 years for the board to review your application and make a decision. And, as we see, most of them do not approve those applications. So this is why it's important to apply both for discharge upgrade and VA character of service determination. And you probably want to start actually with the VA character of discharge determination because, as I said, you get those practical needs met while you wait for the discharge upgrade. Another reason why you might want to do these at the same time is that a lot of the evidence that you're going to gather is going to be the same. So while it's a different process, it's the same evidence for the most part. So how do you apply? Each military branch maintains a Board for Corrections for Military Records, or a BCMR, and a Discharge Review Board, or a DRB. You first want to figure out which one to apply to. So it depends on when you got out and what branch of service you were in. If you were discharged less than 15 years ago, you should apply to the Discharge Review Board for your branch of service. If it has been over 15 years since your discharge, or if you already applied to the DRB and were denied, then you go and apply to the Board for Corrections for your branch. So, the discharge review boards. A DRB can upgrade a discharge unless it resulted from a general court-martial, and they can change the reason of discharge in most cases. You have 15 years from the date of your discharge to apply to a DRB. The Boards of Correction for Military Records. The BCMR can do everything that the DRBs can, and they can also do record corrections and review a denial from the DRB. You can apply to the BCMR if there has been 3 years from the date of your separation, from a discovery of an error or injustice in your records, or from your application and denial from the DRB. Now, the BCMR will also allow veterans to file if it has been longer than 3 years in the interests of justice. Quotes. Again, legalistic word salad. Another reason why you want to get help. But let's talk a little bit about what in the interest of justice might mean. So, for example, if there was a change in the procedure, the rules, and the regulations during that intervening time that you didn't have access to because it didn't exist when you applied, then it would be in the interest of justice for you to be able to file. A good example of this is the CalTAP memo. It came out in 2017, and it directed the boards to offer veterans a reasonable opportunity for relief if misconduct was prompted by mental health or military sexual trauma. So if those were the circumstances of someone's discharge and they tried this process more than 3 years ago, but before the CalTAP memo, it would be in the interest of justice for them to allow you to file. Now, don't just turn in the form. You want to add all that evidence to support it. Your statement, copies of your service records, copies of any documents that are relevant to show why you were experiencing a hardship at the time of the alleged misconduct that led to your discharge. Again, statements from family, friends, service members you served with, lay evidence. Also, you want to point out post-service highlights. You've got a job, you've got a positive lifestyle, you have a family, things that show that you've been being a good citizen. If your discharge is related to PTSD, other mental health conditions, TBI, traumatic brain injury, and or sexual assault or harassment, there are special rules that benefit your application. That's what I was talking about a little bit before, the CalTAP memorandum and other rules, and also just the general understanding of these issues that have come about in more recent years. Go look at the Discharge Upgrades and Records Corrections materials for more information on these issues. Now, you can make a personal appearance before the board. Now, this is an administrative hearing. It's not a trial. You won't be cross-examined. It shouldn't be adversarial. The purpose is to determine whether your period of service was properly characterized. The purpose is to look at all the circumstances and allow you to explain what they are and tell your story. So again, see the documents for more information about how to ask for a hearing and how to prepare for a hearing. Now, if you apply to a DRB, it's almost always better to request a documentary review first, even though a personal appearance review do have a higher success rate. That seems weird. Why is that? It's because if you choose a personal appearance first, you forfeit the right to that documentary review later on. So doing things this way, doing the document and then the personal appearance, gives you 2 bites at the apple. So how do you apply for records correction for the narrative reason of separation as opposed to the type of discharge? The forms are the same as the forms and procedures for applying for a discharge upgrade. However, the evidence you need might be somewhat different. So for example, if you got a discharge with a personality disorder, but later on a psychiatrist or psychologist diagnosed you with PTSD, this would be a change in the narrative reason of separation. And why would you need to do that or want to do it? Well, one is that a personality disorder might be considered a pre-existing condition and that it wouldn't be service connectable. So you'll need to tell the board not only why the narrative reason is wrong, but also what the correct reason should be. Then the boards are required to issue written decisions analyzing all of the issues you raise, and it's going to take a while. It's going to take a year or two. So they do have a rule for veterans with PTSD or traumatic brain injury that should shorten the waiting time, but I would not say that it's going to be quick. And remember, don't do it alone. Seek assistance. When I talked about all of those strange terms of art, those legalistic terms of art and those processes, there are people out there who know about them, they've done it time and again, and you want to get their help with it. So, you ready to get started? See the documents for more information and links for legal representation and assistance. And remember, whatever your DD-214 says today is not necessarily the end of the line when it comes to getting connected with VA, getting benefits, or just having your records, your DD-214, reflect your actual service. So go ahead and pursue a discharge upgrade or a military records correction. Thank you for joining us.